where there are a number of international instruments which are frequently analysed or discussed both by courts and by academics when considering how the legal framework might apply to people who have to move from their home countries as a result of environmental and other degradation connected with climate change. And I'm going to go through a number of these. Right at the heart of it is the 1951 Convention on the Status of Refugees, but we also have a number of civil rights conventions, including the International Covenant on Civil and Political Rights. There is a convention relating to stateless people. There is the United Nations Framework Convention on Climate Change, of course. There are soft law instruments such as the 1998 UN Guiding Principles on Internal Displacement, and there are other agencies or international organisations which are considering climate change displacement, including the UN Security Council. Let's start then with the 1951 Refugee Convention. This was an international instrument negotiated in the aftermath of the Second World War, a time when there were large numbers of displaced people, some who had fled from the Nazi regimes in Europe, also people who had had to leave their countries because of persecution, because of some characteristics of them, their membership of particular races or religions, etc. And so this international convention definition of refugee reflected that time. At its heart, as you can see, is a fear of persecution for reasons relating to race, religion, nationality, or membership of a particular group. Now, what was appropriate in the aftermath of the Second World War is not necessarily reflective of the reasons or all of the reasons why people are required to or have to flee from their countries now. And so, as you might imagine, the concept of people fleeing environmental degradation, or the concept of an environmental refugee, is not covered by this refugee convention, not on the face of the text at least. Some lawyers have investigated some creative ways to get around that. You can have a look at some of the commentary on that. But essentially, the definition of a refugee under the 51 Convention doesn't cover people who have to flee their country because of environmental degradation. A little more hope might be held out for people who are required to leave their countries under some of the international human rights instruments, including this 1966 International Covenant on Civil and Political Rights, or the ICCPR. A number of rights are affirmed in that document, including Article 6, the right to life, and the requirement that no one be arbitrarily deprived of their life, and also the Article 7 prohibition against torture or cruel, inhuman, or degrading treatment. New Zealand has ratified the ICCPR. It's explicitly referred to in our New Zealand Bill of Rights, and it's also referred to in our immigration legislation, which I'll come to in a minute. The third important convention is the Convention Against Torture from 1984, and you can see there the prohibition against people being required to return to their country where there are substantial grounds for believing that they would be in danger of being subject to torture. Torture is defined widely to include torture or cruel, inhuman, or degrading treatment or punishment. And so some arguments have been developed that requiring people who have travelled to another country, such as New Zealand, to return to their country where they may be at risk of various forms of harm relating to climate change or environmental degradation would not only contravene the ICCPR but also the 84 Convention on Torture. How is this reflected in our immigration legislation? Well, our Immigration Act 2009 incorporates the international definition of refugee under the Refugee Convention and affirms that if you are a refugee under the Convention, then you are a refugee under New Zealand law and you cannot be deported from New Zealand except in some very rare circumstances. New Zealand's Immigration Act 2009 also recognises that people can have what's called complementary protection. So if someone is recognised as a protected person under the Covenant on Civil and Political Rights and elsewhere, the Immigration Act also recognises that if people are protected under the Convention Against Torture, then similarly they cannot be deported from New Zealand.